Before you sign a MassHealth application, there's a lot to read and think about. The item in the MassHealth application that we're looking at today says, to the extent permitted by law, and unless exceptions apply, for any eligible person age 55 or older, or any eligible person for whom MassHealth helps pay for care in a nursing home, MassHealth will seek money from the eligible person's estate after death. Did you get that? The cost of anything MassHealth pays for, doctor visits, medication, home health aides, as well as nursing home care, can be recovered if you leave assets in a probate estate. And that brings us to the court case of estate of Jacqueline Ann Kendall, who owned a half interest in a rental house in Gloucester when she passed away in 2014.
In the case of Ms. Kendall, she was never in a nursing home. She received all of her care in community settings. And she died intestate without a will.
The Kendall case started in 2018, 4 years after Jacqueline Kendall's death, when her family filed a probate petition for late and limited probate so they could sell the rental house. As required by the probate rules, the family notified MassHealth, and then another probate petition was filed by the Estate Recovery Unit, claiming Ms. Kendall owed $104,000. Other creditors in Massachusetts have only 1 year after the person's date of death to file a claim in court. MassHealth's special status that allows them unlimited time to latch onto assets in a dead person's probate estate got the attention of Massachusetts' highest court. The justices decided to hear arguments from Ms. Kendall's family.
Counsel, may I ask you a question? Is your position then that there has to be a deadline? Because otherwise, if we adopt the position of MassHealth, we're going to eliminate the statute of limitations or the statute of repose, and these things will be open forever, and there'll be no closure or certainty.
Exactly. 20 years from now, MassHealth could find an unpaid claim in its file and try to claw back those what's been distributed already, and try to bring in the personal representative 10, 20 years later.
Yes, this could go on for years and years and years. No estate is opened. MassHealth doesn't learn of the death, and people are living in the house or renting in the house. In this case, the residence was rented out during this 3-year time period.
The ultimate time limit for filing a probate estate is 3 years. There are some exceptions to the 3-year time limit, but MassHealth Estate Recovery is not one of the exceptions. The estate recovery claim against Jacqueline Kendall's estate was time barred because the estate was filed in probate more than 3 years after she died. The rental house in Gloucester was freed of the lien, and the family could now keep all of the real estate sale proceeds that had been held in escrow. So for now, if a deceased person's estate isn't filed in probate court within 3 years of his or her death, MassHealth Estate Recovery can't collect from probate assets.
How we protect against the clever lawyer like you who says, wait 3 years, and you get to have your cake and eat it too. So how is the state protected against that?
MassHealth could even start tightening up its surveillance of death records, cross-check the deaths with its payment computer, and start filing its own probate petitions within the 3-year deadline so that public administrators can go after the estates. One thing is certain, you can save your estate from Medicaid estate recovery if you understand the rules and don't leave assets behind in probate. To learn more about how Medicaid estate recovery could affect you and your family, watch the complete 10-minute version of this video by clicking on the link below.